Which section of the Code of Criminal Procedure empowers a magistrate to make arrests? We already made a mention of this provision in the last question. The answer is section 44. There are 4 sections which authorize different persons to make arrest, starting with 41, ending with 44. We will make a quick revision again. Section 41 authorizes a police officer to make an arrest without warrant. Section 42 also authorizes a police officer to make an arrest in case of even non-cognizable offences where the accused does not tell the name or residence or he tells them wrongly. Under section 43, a private person can make an arrest under certain situations, and under section 44, a magistrate can make arrest or even cause arrest if an offence is committed in his presence. Question 14. Who can file an appeal under the Code of Criminal Procedure against a judgment of acquittal? Now, this is a difficult question and it will have a long answer. It is not one person only. There are several persons who can file an appeal against a judgment of acquittal. Let us see who all can file an appeal. The relevant provisions are contained in 378 and 372. Under 378, first subsection, the district magistrate will authorize the public prosecutor to present an appeal to the Court of Session. So from this subsection, we say that the person who can file an appeal in a Court of Session against an order of acquittal passed by a magistrate is the public prosecutor. He, of course, will need an authority from the district magistrate. So the first person who can file an appeal against an order of acquittal is the public prosecutor under 378(1)(a). Under 378(1)(b), once again it is a public prosecutor, but here he will file the appeal on directions from the state government. Then there is one more provision, subsection 2, where also the appeal shall be filed by the public prosecutor but on authorization from the central government. So in these 3 provisions, we see that the authority which can file the appeal against an order of acquittal is the public prosecutor, but he will do so on authorization from different authorities. Authorization may be there from the district magistrate, from the state government, from the central government. But in all these 3 cases, the authority which actually files the appeal is the public prosecutor. In 4th subsection of section 378, the complainant is empowered to file an appeal against an order of acquittal. This, of course, will happen only in those cases which have been instituted upon a complaint. And before an appeal can be filed to the High Court, the complainant has to seek special leave. Another point that is to be noted is that when the complainant desires to file an appeal, then the appeal can be filed only to the High Court, not to the Court of Session. So this is the second person, public prosecutor so far, and now complainant. And there is one more person who can file an appeal against an order of acquittal. That person is the victim. And the provision is there in section 372 by way of a proviso. This provision was inserted with effect from 2009. And for the first time in 2009, the victim was given a right to prefer an appeal against an order of acquittal. So as of now, we have 3 different authorities or persons who can file an appeal against an order of acquittal. Which are these? Let's summarize. The victim under proviso to section 372, the complainant under 4th subsection of 378, and the public prosecutor under first and second subsections of 378. The victim, the complainant, and the public prosecutor. These are the persons who can file appeals against an order of acquittal. Question 15. Which section of CrPC makes it mandatory for the police officer making arrest to inform about the arrest and to inform about the place where the arrested person is being held to a nominated person? The relevant provision of CrPC is section 50A. It requires every police officer or every other person making an arrest to give the information of arrest and also of the place where the arrested person is being kept. And this information is to be given to at least one person who may be a friend of the accused or arrested person. He may be a relative. He may be a person who has been specially nominated by the arrested person to be informed. And who is to give this information? Whoever is making an arrest. As we saw in the earlier provision, a police officer can make arrest, a magistrate can make arrest, even a private person can make arrest. The relevant provision is section 50A. Question 16. Who is empowered to withdraw prosecution of any person at any time before the judgment is pronounced? Withdrawing of prosecution. The relevant provision is section 321 CrPC. It is the public prosecutor or the assistant public prosecutor in charge of the case who may withdraw from the prosecution, and this can be done only if there is consent of the court. This can be done at any time before the judgment is pronounced. So under section 321, it is the public prosecutor or the assistant public prosecutor in charge of the case. He can withdraw from the prosecution with the consent of the court. 321. This section comes just after 320, which contains provisions relating to compounding of offences. Question 17. Which section of CrPC provides free legal aid to the accused? Section 304 is the answer. Section 304 applies to a trial before a court of session. Two conditions must be required, must be fulfilled. Firstly, the accused is actually not represented by a pleader. And secondly, the court is satisfied that the accused does not have sufficient means to engage a pleader. If both these conditions are satisfied, then it is mandatory, it is obligatory on the court to assign a pleader for the defense of such an accused. And this will be done at the expense of the state. That's why we call it free legal aid. But this applies only if the accused does not have sufficient means to engage a pleader. It is not available to everyone.